Um, Here to go. Good to see you all in good shape. We have a quarter to 10. We start again. Welcome to the next session of Law of the Digital Economy. Hi. So my name is Thomas Hoeren. I'm telling you a lot about the law of the digital society. We have started our journey with copyright law, intellectual property rights, based on this assumption, which cannot be justified. Information wants to be free. Information is free, it belongs to nobody. That includes digital information. So we have checked the exceptions from the rules. There's a new regime on software protection. Every software is protected by copyright law. There's a database sui generis right for the collection and structuring of data. And apart from that, we have a mixture, a bundle of various ideas of the ECJ, totally confusing, like called acquis communautaire. Then we have seen closing the chapter on IP rights. We have a session on unfair trade law. We started to check how the trade in digital information is controlled, including AI. And now we are starting with a third step, that is e-contracting and consumer protection. I want to mention one feature which might be coming up in the final exam in January. It's a good tip for your preparation of the exam. One of my favorite questions, which I always ask, is the question, which rules on private international law govern the digital society? I tell you the answer. For instance, we have found out in copyright law, there's a principle of territoriality. That means you have to find a territory where copyright is used. We have in unfair trade law, we have the principle of marketplace. We have to check where is the relevant marketplace for doing trade. We will see in the lecture on data protection, it's a mixture in private international law of marketplace principles and the seat of the person concerned. And we'll see in e-contracting, and now I'm starting with the lecture on e-contracting, when you want to find out which principles of private international law are governing contracts, we have to find out the principle of freedom of finding a relevant law. We can simply make a choice of law clause in a contract and say, I want that the whole contract is governed by the law, for instance, of the United States. Very bad decision, because you don't have all the United States of America, you have single states. And so you have to decide in the choice of law clause what is the relevant law of a state. For instance, most American companies tend to say, we want that this contract is governed by the law of California, or take Delaware, as a liberal state, which you can use for making a nice arrangement. So if you are not using a choice of law clause and you're silent as regarding contracts, there's a rule saying the law of the country is relevant where the party has its seat which doesn't pay, because payment is regarded in private international law as bad. So you have to find the person under contract who is bound by non-money duties, simply the seller of a product, and his law is then irrelevant. That is, for instance, for Germans regulated in the EGBB. That's a very simple rule. Follow the non-money. The non-money duties determine the relevant law. We'll see that this rule is very nice, but it does not apply in consumer protection. Because again, we have European regulation on relevant law, and it said that a consumer cannot waive his consumer protection by contract. So in consumer protection, the law of the seat of the consumer has to be applied. There's an exception of the rule that you are free to decide on the relevant law. So coming back to the test at the end, you have to describe all these principles, or at least to find in the multiple choice the relevant criteria and determine which has to be applied in the unfair law, trade law, which has to be applied in consumer contracts. That's a very favorite question. I hope you have understood that, and we'll test your knowledge at the beginning of January, because we have a test exam at the beginning of January where you can determine, do I know everything or am I stupid? So there will be a testing period for you. I don't want anybody is failing in the multiple choice test. So fine. Now we know the date. I know the date. It will be the first week of January. Not the 1st of January, but the Monday after the 1st of January, we will disseminate an electronic test for your testing purposes, which you can use and play in order to determine, do I know enough to pass the final multiple choice test. So everything fine? You look lovely today. E-contracting again. Coming back to e-contracting. I usually start with saying which regulations are applicable on an international basis. Are there some international conventions for e-contracts? And there is the famous UNICTRAL rules from 1996. Of course, the EU has started to harmonize some aspects, and we have, of course, a bundle of different national rules. Let me start by talking about UNICTRAL. UNICTRAL has its seat in Vienna, is very important for Georgia and Uzbekistan, but as well for Germany. They have over several years started as a discussion on e-commerce and e-contracts. And they have made a model law of e-commerce, which is the basis for many jurisdictions to change their attitudes. It was made in 1996, and the principles of UNCITRAL are always the same. The principle of non-discrimination, that means any document cannot be denied legal validity solely on the basis that it is electronic. So it's not allowed to say you need paper, and if you don't use paper, it's not accepted. Second principle, technological neutrality. Is not allowed under the UNCITRAL rules to use certain technique and to say every citizen of Uzbekistan needs to have this technology. So you have to be open for future development. Functional equivalence principle means specific requirements that the e-communication should meet in order to say it is similar to traditional paper-based system for writing on the original. So every member state should determine when is an electronic document equivalent to a written document. Because this UNCITRAL consists of two parts. The most important regulation in UNCITRAL is Article 2. As the definition part is rather broad and says everything, every information generated, sent, received, stored by electronic or similar means is included. So it's a rather broad definition. The legal requirement says the nation is required a document to be in writing or validation, are not allowed to say it's necessary a handwritten signature. So there should be a requirement to open their national law to electronic signature. So uh, there is a UNCITRAL rules when we have a look on the EU regulations in the area of e-contracting, we will not find any regulation. The Commission only has a view on consumer contracts, not necessary on B2B contracts. It's not a topic for Brussels. So as a third step, after UNCITRAL and the EU, we have to check national law. And that is, of course, my favorite time of the lecture, because this national law is known to my students here in Münster because they are very brilliant, starting with this first semester. Let me take a checklist to determine how e-contracting generally is regarded in European civil law. Of course, my students know a contract is made by agreement of an acceptance. In UK, you need a consideration. So you have to, one party is offering a good, the other is paying for that. That's called the payment consideration. Who is able, that's a favorite question, to close a contract? So especially regarding minors. A contract needs to be legal. If it's illegal, we have a provision saying it's void. And it has a certain form, sometimes question of formalities for contracts. And let's start with offer and acceptance. The question is, who is making an offer in a digital world? Is a website an offer? What do you say? Is a website an offer? There's one nice Latin word for that.
Oh,
Yeah?
no.
Maybe it's comparable to indicatio ad offerendum.
Yeah, she is able to speak perfect Latin. It's called invitatio ad offerendum, an invitation to treat. That means it's only advertisement, no legal validity. Is it the same for all countries in Europe? Do you know, does anybody of you know in which country is a homepage binding? There are two countries in Europe which don't believe that a homepage is non-binding. It's not Italy. Where you come from? Yeah. Is a homepage binding in Italy?
Sorry.
Is a homepage binding? As invitatio ad offerendum. So it's not binding. So it's not the same for France and Spain, because in France and Spain, they don't accept invitatio ad offerendum. So if you're saying anything on the homepage, it has legal validity. Even in Germany, we have some exceptions where a homepage itself is binding. Can anybody imagine what it is? Now, if you have any electronic goods which you offer on the internet, take for instance, music for download, then of course, offering the music on the homepage is itself binding. You can simply say, I want to get the music, and then it's okay. So, very, very important, automatic declaration of the intent. Can a machine give an offer or acceptance? Let us use the example of AI. Can AI as a robot order for you anything which you want? Yeah.
I don't think in German law because it doesn't have a Rechtspersönlichkeit.
Yeah, that's true. To say it from a dogmatic point, an offer is defined as Willenserklärung, a declaration of will. And will is traditionally understood as human will. So you need to find a person, a real person who declares his will. Can you find the lady here in the room said, no, a robot, an AI cannot declare will. But is there a person a natural person behind an AI, automated machine. So we could in the past say the machine is programmed by a natural person. And he said, I want to have that declaration attributed to me as a programmer. So yeah, sometimes I can find traces of a programmer who is able to say, yes, this is my will expressed in a machine. Is that always the case? Because AI, for instance, is working at a stock exchange very quickly and is ordering papers and selling papers at a financial auction. So it's done in microseconds. And you cannot trace back a natural person who is willing to say, that was me. So it can be very, very complicated to trace back an AI decision to a natural person. Next topic, contestation of a declaration of intent. What is happening if you're declaring, I want to get 5 kilos of sweets, and in fact, you wanted to get 5 grams of sweets. So you made a mistake, an error. Can you say, I want to cancel it? What is happening when you are making a mistake in an electronic order?
Trying to withdraw an order.
Hmm. What do you want to say?
I think in Germany we call it a Fernabsatzvertrag.
No, that's consumer protection. No, in general, civil law. Can you cancel a contract if you make a mistake?
Only if both sides agree, I think.
In Germany, we have a nice solution. The contract is not void, it's valid, but you can ask for cancellation of your statement of will. That's not the solution we have in France, and that's not the solution we have in your country, England. Because in England, for instance, they have a tendency to say, well, if I make a mistake, that's not your fault, it's my fault. And so you're bound by a contract. So the British, of course, tend to stress freedom of trade. It's a violation of the freedom of trade if I would be allowed to say, I have made a mistake, sorry, I want to cancel the contract. In France, it's the other way around. In France, they would say, that you even don't need to cancel it, it's simply void. Because you made a mistake, you haven't declared to get 5 kilos of sweets, you wanted only to get 5 grams of sweets, so it's not a contract. So, of course, the best solution can be found in Germany, exactly in the middle of the British principle and the French principle. The contract is closed. And if you want to cancel, you can say, sorry, I made a mistake, but you have to pay compensation. So it's exactly in the middle. Does it apply as well to calculation error? Imagine I send an email to another person asking for 5 kilos of sweets, and I say, I want to get a second package of 5 kilos. So I want you to order to get 15 kilos. 5, 5 equals 50. That's very bad in logic, in mathematics. That's very bad. You made a mistake. Can you cancel that? So very simple question for the first term of the law students. So the German law says you can only cancel it if this calculation error is open. If it's very simply to be understood. 5 plus 5 equals 15 is a very, very bad solution. This can anybody explain, understand. That is not a valid contract. So if the error remains secret because it's a long list of calculation, and there's one error in the middle, that cannot be cancelled. The most important problem of mistakes and errors is a transfer error. Imagine you are sending on the internet a message, please send me 5 kilos of sweets. And at the end of long journeys through the internet, the system says 50 kilos. So your message original was 5 kilos, at the end 50 kilos. Is that a mistake? Can you cancel it? That has been decided by the Federal Supreme Court in Germany and in France. That's called a transfer error, and it can be cancelled, but you have to pay compensation if you cancel it. So, the next topic, how do you pay on the internet? That's a practical issue. I think that nobody is using e-cash or digital cash. You can use bitcoins. We are talking about bitcoins next term. Everybody is using checks, credit cards, of course, but then that's not a problem for civil law. What is the evidential value of electronic declarations? What is happening if I'm not saying I made a mistake, but please prove that I have ordered anything? In this room here, we had the attorney of Microsoft, of Amazon. He gave a lecture, and I asked my students, how many orders are simply cancelled by somebody who's saying, I haven't ordered anything, please prove that I have ordered anything. How many percent are cancelled on Amazon? Please give me your ideas. How many people are saying, no, I haven't ordered anything, sorry?
Maybe every 10th order, so 10% of the orders.
Another figure?
I would say up to 20%.
24, so I've heard.
Sorry, what was the question again? Someone says they didn't order anything on Amazon.
How many orders on Amazon later are called by the words, I haven't ordered anything?
It's probably increasing, maybe 20 to 25%.
He said nearly 50%. And that is killing, of course, small and medium companies. Amazon is so big that it doesn't matter. But if you're small and medium, it will kill you. So what is the evidential value of electronic declaration? How can you prove that somebody really ordered a good It's very, very complicated, and I will come to that in minutes. And you see one question with three question marks: data ownership. To whom belong data? Who is the owner of data? Do you know how many data are stored in a Volkswagen? Every time you're driving a Volkswagen, it's nearly 1 million data. There's three big computers stored in a Volkswagen responsible for checking all the data in the car. So who is the owner of these raw data? Is it Volkswagen? Or is it the customer, the buyer, the owner, the holder of the car? Very, very unsolved. And I can tell you, if you want to write a doctoral thesis here at the Institute, you are, of course, hardly invited to do that because I'm desperately looking for somebody writing a doctoral thesis about that topic. Because ownership, we can only become owner if you have tangible goods, Sachen, we call it Sachen. The raw data are not tangible goods. No? Can you use the database right? The database right, which we are talking about, is only there for structuring and collecting in an intelligent manner data. It's not exclusive rights in data, but in a database as to structuring and organizing it. So it was not solve anything. Is it data protection? But data protection will be a topic in December, only protects personal data. So not raw data without any trace to a certain person. So it still is an open question, who is the owner of data? So here you have, of course, it's a question of invitatio ad offerendum, which you just said. So offer is a proposal, while an invitation to offer is inviting someone to make a proposal. Exception is France and Spain, and the exception is electronic goods. As to automatic ordering, can a machine give an order? We have certain decisions from Germany and France. Here I have one decision of Augsburg local court where a buyer used a bidding machine via eBay bidding assistant, and the court said this can be traced back to a natural person. So this is the question for minors. Data ownership. I've written down one decision from Brandenburg, where the court has said data is not property, so the law of possession cannot be applied. An analogous application must also be rejected, and I hate this court because he cited me and said, see, is a stupid law professor called Hoeren, and said he had a totally wrong idea to apply law of possession to goods. And the value of electronic documents, how can you use electronic documents as a proof that somebody has really ordered anything? You see the problem using the Court of Appeal of Turin. They have checked, can you say that electronic documents are documents like paper documents and can be used as proof, as an evidence tool for using them similar to paper? The court said no, it's not possible. A screenshot in paper form has no value, so you cannot use it. So we have seen 50% of people which are able to say, I don't order anything using them. So can we say under British law, yeah.
Yeah, I have a question about automated offering, because in current law, are there any gaps? The decision or the offer of a machine can be traced back to a natural human because of like black box or self-learning process. And then there's no liability of a human, and AI or the machine can't be liable. So there is a gap in liability.
Of course, when you use AI for giving orders, massive orders, hundreds of orders, you cannot trace back these orders to a natural person. Then you can only say that the machine did it. And then we have a big gap, because some people say when we cannot trace back an order to a natural person, it's the AI itself who is ordering. That is requiring a kind of e-person personality. So then we need to say the machine is an e-person and gets the same rights as a natural person. Some people and with the strains, I think, yes, we can do that. But how can you integrate e-personality in traditional civil law? So no liability, no binding offer, nothing. So then other people say, of course, the programmer has programmed the AI so you can trace back the errors of the machine to errors of the programmer. But if the machine is making thousands of orders and one order is bad, can you really trace back this error to the poor programmer, for instance, of OpenAI? There is a lot of courts decision needed to find a solution. But I think you should write a doctoral thesis on that. So one British question, consideration. Can we say if somebody is buying anything and is paying for it, there's of course a kind of consideration. In the lack of a consideration that's British, the contract is in general void. Am I right?
Sorry.
Is a contract without a consideration considered to be void?
Yeah, without consideration, yes. Yeah.
Yeah. For us in Germany and France, that's a new word because we don't have any consideration. So in Europe, we are asking ourselves, what is happening if somebody is using a free service like Facebook or Google? There's no consideration. Can you close a contract with Google and Facebook without consideration? Of course not. So there's a new directive, the first directive foreseen first for consumer rights on certain contractual rights of the Commission of Digital Content. And there the Commission has a nice view, again, a good topic for Dr. Cvil, to say that giving away your data, personal data, can amount to a consideration. So you're paying Facebook or Google with your data, personal data. It's a nice idea, but I said, hellish laughter, because does it solve any problem in internet law? No. No court until now have used that concept to say that data is a consideration.
I would still agree. It's the whole, I would remove the whole basis of consideration, because for each website you go on, you consent to your data, cookies, social media, to remove the whole basis of consideration from because that means everyone's given consideration about knowledge.
Of course, any user of Facebook is accepting to give away his data, but they cannot be considered as consideration within contract law. So let me see what we got. Consumer protection. That's this. So in consumer protection, things are getting worse because consumers are the most favored persons for Brussels. There are powerful consumer organizations who are strongly fighting in Brussels to get consumers protected. Therefore, we have the distance selling law, and only to describe what is in the law, information duty, and the consumer needs to be informed about things going on the homepage. We have checked it as the institute, and we have found out that more than 103 information are necessary on the homepage. So you need to inform who you are. In an impressum, you need to find a separate button to say, this is describing who I am, my legal status, my address, and so on. You need to describe your goods. So what do you offer, for what price? All parts of the prices should be explained. You need to describe all the costs for sending a good, certain good. It has to be open. And then you have to give the consumer a right to withdraw the contract. He can, without reasoning, withdraw any contract as a consumer he wants. He has closed via the internet. And the time for cancellation is 2 weeks. It's very complicated. When do the 2 weeks start? But 2 weeks. And if he wants to cancel the contract, he is getting his money back, which he has paid for the good and for the transportation of the goods to him. But he has to pay the re-transport to the other side. And that's his duty. So, and you need 3 buttons on the website. One button saying, the consumer wants really to order. There's always an order button. The second button is a button for cancellation of contracts. So there's a second button, and a new button will come in 2025. That's a button to withdraw any contracts on the basis of distance selling. There's a third button which needs to be explained. All these buttons are regulated in the Consumer Rights Directive of the new one of 2024. So there is a very, very, very quick survey on the rights. Now I will go. Do you have further questions on e-contracting and distance selling? It doesn't seem to be the case. Then I want to talk on the problems of liability. Because we have a really big problem regarding software in general and product liability. The problem exists since we have a high risk of robots making mistakes. You can see here this famous robot, which is used in automatic cars. Imagine an automatic car is making a terrible mistake and an accident. Who is liable for that mistake? But you don't need that typical case of liability in automated cars. Simply use AI smart metering system. The whole house is controlled by an AI system regarding the electricity. So if that tool makes a mistake and sending too much electricity to the house, that costs money, can cause damages, and that causes liability. The traditional system, of course, of liability law in the EU is on the right side, contractual liability. There's a typical liability every member state is regulating. For me, the important thing is the extra contractual liability, because AI may cause damage not only to the contracting parties, but also to third persons who are, for instance, part of an accident by an automated car. Then you have extra contractual liability, and in the middle you find the typical instrument for using that is tort. Negligence liability and liability for negligence. The negligence might either be fault-based or might be especially regulated negligence with extra data. Apart from negligence, we have strict liability. That is a typical system in Europe. And now the Commission is planning two different directives on increasing the liability for electronic systems. On the one hand, they are planning a special regulation on the liability for AI. Express AI liability regulation. You see, they have made already a long list of papers starting in the 2005, I think, and the end 2022, they made a proposal for an AI liability directive. What is regulated in the AI liability directive is aimed at improving the functioning of the internal market, to promote the uptake of trustworthy AI, and especially to ensure that victims of harm caused by AI get their money. And all this is done by a procedural approach. They're changing the procedure. That means they are changing the rules for the court to get documents in order to prove liability. So a court may, at the request of a claimant, order the disclosure of relevant evidence relating to certain high-risk AI systems, which might especially cause harm. So the court is free to decide, you have to open the books. So give us the documents. If somebody is suing, you need to open all your files in the company. It is only valid for high-risk AI systems. We'll discuss about the AI regulation next term. And the AI regulation uses the term high-risk AI systems. So if you can prove that an AI system might lead to a high risk of harms, then you are within a category of AI systems, high-risk AI systems. So first, the potential claimant must demonstrate that he has done everything to obtain the defense evidence from the defense. Then the court needs to be very aware not to open too much of the files. So the limitation is the disclosure is necessary and proportionate. And so if you're asked by a court to open your files, and the court has said it's necessary and is proportionate, you have to give it and open it, and the other party is not doing it, then it is presumed that the defendant has breached its relevant duty of care. So the standard level of proof which you need is decrease. So it's a presumption that an AI machine has caused a certain damage. That is new. That sounds very, very nice, but this directive has one disadvantage. It's not finished. So in Brussels, they stopped the discussion on the directive we have used our channels to get information why they stopped it. They said we have done so many regulations on AI now, we are tired. So, and there's a new parliament, and the new parliament needs to decide, do they want to further adhere to the decision? But apart from this first directive, then a second directive, and that is already finished. As I've sent you, at the 23rd of October this year, the directive on defective products has been published. This is so-called product liability directive. If you take this text, you have it in front of you. It's a long directive. The English text was made at the 18th of November, just last week. Here is a chance to understand the structure of the directive. It started with a certain part, whereas on the first page there is a long recital considerations of the Commission and Parliament to understand why they did it. Do they have any impact? That would be a question for you. Do this consideration, preliminary consideration, have any impact? No, in general not. They only give a general background for understanding why they made it, but it's not used normally by the ECJ as the decision made already in the 70s of last century. The ECJ never considers the preamble. That's different from the German courts, who are always looking for the historische Auslegung, historic interpretation. So the historic interpretation is normally not part of the European Court of Justice. So the directive started with Article 1, that's page 11, and describes a new system of liability. What is the sense of the directive? The planned amendment aimed to adapt the regulations to the digital age and technological progress, especially by extension of liability to software and new technologies. We had already product liability directive in 1995, and there was only explained it relates to the liability for products. Products is a good, and a good is a tangible good. So in the old product liability directive, it was very controversial whether software can be considered good and then a product. Now it's made clear this product liability rule is applicable to software as well as to AI. So it was expressly made for anything which has to do with the Internet of Things. So in this new directive, software is explicitly categorized as a product. Excluded from liability is free open source software, but for instance, included is CAD software. Well, what is CAD software? Does anybody of you knows what is CAD? Any father who is an architect? That is software for constructing a house, which helps to design a house as an architect. So, and if it's that, for instance, is included, that means you are fully liable for any mistake made by a CAD software. If the software is making a mistake in constructing a house, you as a software developer are liable for that. Even AI systems or AI-enabled goods are products, so that manufacturers are liable for damage caused by errors in the software without having to prove mistakes. That's the definition in Article 4, number 1. Product means all movable items, even if they are integrated into or interconnected with another movable or immovable item. It also includes digital construction documents, raw materials, and software. That is new. And what is new as well is a person who can be held liable under the directive. In the past, in the old directive, 1995, it was regulated liable is the manufacturer. So who is manufacturing a good? Of course, somebody who's using his own hands to produce a good. This definition has now been changed because manufacturer is a manufacturer of a supplier part as well that is integrated into the product. And if the manufacturer is living in China and you are importer or representative in Europe, you're also a manufacturer. You're considered to be a manufacturer. Even if you are only a service provider, you're storing Chinese goods, you are regarded to be fully liable. On the third level, if there is no subject of liability under the level 1 and 2, so nobody can be traced back as the original manufacturer and even as a quasi-manufacturer, even the trader and provider of an online platform is considered to be liable. So long list, even if you take it like that, Amazon is liable for any products sold by Amazon. So any party, so the importer, authorized representative, service provider, distributor is liable if the original manufacturer cannot be traced back. And we have an additional extension of the scope of liability. In the liability directive from 1995, it's only said you are liable for putting a certain product on the market. So in the moment where you have put it on the market, you are not liable anymore unless you know or need to know that a certain mistake in the product has occurred. Then you have Belehrungspflichten, you have to call back a defective product and so on. Here you have an extension to say a manufacturer can also be liable for changes to product which he has already brought to market if these changes are triggered by software updates or machine learning. That is a very important understanding. The liability includes cyber security, that means even hacking. So we have a new liability for the behavior of third persons as well. What is as well changed is the Commission put away all the limitation as to the amount of money. In the old directive, we had a limitation, for instance, a minimum limit of 500 euros for damages occurred, and a maximum limit for personal damages. All these limitations are now away. They are not in force anymore. So, to summarize it, the reform provides for the extended obligation for manufacturers and retailers, particularly with regard to risk analysis, technical documentation, and product compliance processes. So, I hope you all see